Hello and welcome to the podcast by Cleaver, Fulton, Rankin. I am Conor McCrory, an associate in Cleaver, Fulton, Rankin, practicing in immigration law. And today's podcast is on the United Kingdom's process for hiring highly skilled employees. I have worked in London within this ever changing area of law for the last 10 years. And in 2018, I joined Cleaver, Fulton, Rankin as an immigration associate, assisting small, medium, and large corporates to provide a wide range of legal support for the business immigration needs of our clients. This can be from managing the entire Tier 2 process to ensure successful approval of any visa application, whether straightforward or indeed complex, to the dealing of sponsor license compliance issues, which would be ongoing obligations under any functioning sponsor license. This webinar will look to cover a basic background of how the UK immigration system operates, with reference to tiers 1 to 5 of the points-based system. These would be widely regarded to be the main visa tiers for businesses in Northern Ireland and in the UK for highly skilled migrants. We will focus on the two main employment visa categories under Tier 2, namely Tier 2 General and Tier 2 Intercompany Transfer. I will identify some of the main considerations when dealing with these visas, looking at salary and other areas which might require some further attention. This webinar will be particularly useful for companies who may be considering the need to apply and obtain a sponsor license with the Home Office. I will also touch on the compliance obligations which will be placed on any sponsor by the Home Office. Any questions concerning the content of the webinar, I would be more than happy to assist and help. Contact details will be included should you wish to pose any questions. How the UK immigration system works. The Home Office or the UKVI are responsible for maintaining the operation of the UK immigration system. Back in 2008, the government decided that a points-based visa system would be the main UK immigration route for migrants from outside the European Economic Area, or Europe, to come to the UK to work, study, invest, or train. The system separates applicants into 5 tiers. In order to be eligible for a visa in any of the 5 tiers, you must pass a points-based assessment. With regard to employment visa applications, points are generally awarded according to the applicant's ability, experience, and age. You must reach a point score above a minimum threshold if the application is to be successful. Between each of the tiers, 1 to 5, the minimum number of points required will vary. I think it is useful just to look at a pyramid of the 5 tiers and maybe just making some basic comments in regard to each of the tiers 1 to 5. Tier 1 would normally be for entrepreneurs, i.e. individuals who would be investing 200,000 or more into the UK economy. It may well be investors who would be investing anywhere from 2 million into the UK economy or more. So you would tend to see Tier 1 applications being for private individuals, your typical sort of entrepreneur like Richard Branson, for example, or anybody who has an idea for a business and may look to operate within the UK. However, for the purposes of this webinar, Tier 2 would be the most important. The two main visa categories within Tier 2 applicable to most businesses in Northern Ireland considering bringing in highly skilled workers will be Tier 2 General and Intercompany Transfers. Tier 3 is an interesting visa category It has never really operated, but there are some talk with the government currently about considering using Tier 3 for low-skilled workers. That would be the equivalent of your agri-food industry or indeed manufacturing, who may require unskilled workers or lower skilled workers to fulfill roles within the UK. Tier 4 will be mainly applicable to students, and Tier 5 are more temporary workers who would be coming here on short periods of time, for instance, 12 months, to work within an industry to gain some further skills. We will now look to focus on a very important visa category for employers in Northern Ireland and in the UK, the Tier 2 General Visa category. This allows non-EEA, highly skilled migrants to come to the UK for employment purposes. One of the main areas of consideration for any business in Northern Ireland is to consider the need to pay $30,000 per annum in accordance with the role that is to be offered. Now, that £30,000 per annum salary are for experienced hires, usually people above the age of 26 who have a background within the industry. And although 30,000 is the minimum threshold, it is still very important to look at the occupational codes relevant to that job, which may have an increased salary threshold, which would need to be paid. These occupational codes were preordained codes set up by the government in a diverse range of roles, and they stipulate the minimum salary and experience and skills required for the role. Under this visa category, you can decide whether you want to hire someone new who may not have worked for your business, either abroad or anywhere else. And one of the benefits of this visa category, which I often refer to it as the golden visa category, is because after 5 years of holding a Tier 2 general visa, you are eligible to apply for indefinite leave to remain. In other words, permanent residency. Following 5 years and then obtaining indefinite leave to remain, if you hold it for another 12-month period, you may be eligible, subject to the requirements, of applying to naturalise as a British citizen. A very important consideration of any Tier 2 general application is the need to meet English language requirements. Now, if you're from a majority speaking country like the United States and the main language is English, then you will have met the requirements by virtue of your passport. However, if you are, let's say, an Indian national living in the US, then you will have to meet English language requirements, and that may well take the form of a translated NARIC test, or it may well take the form of actually having to do an English language assessment. For Tier 2 General, not always the case, but it's usual for the position to be advertised for a 28-day period. Now, there are some roles that are on the shortage occupation list, which would bypass the need to advertise for 28 days. But by and large, for any HR department or leadership, they would need to consider possibly advertising the role for a 28-day period. Examples of highly skilled migrants under this visa category are chief executives and senior professionals, engineers, software IT professionals, business development managers, and financial investment analysts. The Tier 2 Intercompany Transfer visa category. This again allows non-European skilled migrants to come to the UK for employment purposes. There are a number of considerations depending on how long that person has worked for the business, and I must reiterate the importance that they have worked for the business. In order for a Tier 2 intercompany transfer visa to be obtained, the company structure must be linked. That might be, for example, you have a subsidiary company based in the UK, other parts of Europe, or the Middle East, for example, and you have someone who is working in your office for a set period of time and who you may require to come to the UK to work on assignment. If you have someone who has worked for less than 12 months in your business, you are looking at having to pay the higher salary threshold of 73,900 per annum. If they've worked for 12 months or more with your business, then it is possible to bring them in for a minimum salary of 41,500. The difficulties with this visa category is, unlike Tier 2 General, after doing 5 years in the UK, you are not eligible to apply for indefinite leave to remain. One of the major considerations of this visa category is that there is application of something called the cooling off period. What this means is that when someone has been in the UK for 5 full years under Tier 2 intercompany transfer visa, they must leave the UK for a period of 12 months before reapplying to come back into the UK. There are some ways around this, such as high earner categories, but by and large, for a lot of applicants, this will be a rule worth due consideration. There are no English language requirements and no advertising is required. Examples of highly skilled migrants under this visa category will be exactly the same as those occupations previously listed for Tier 2 General. Some of the reasons why companies prefer to go for the intercompany transfer visa is it's rather more streamlined in its approach. There are no English language requirements. You don't have to worry about the migrant having to potentially sit an English language test. You don't have to think about advertising the role and monitoring all those applicants who have applied. And so timeframes for obtaining a visa of this category can often be half the time of obtaining a visa under the Tier 2 General category. So the big question for any business will be, how do we get highly skilled migrants into the UK? Well, to put it very simply, you need to obtain a sponsor license with the Home Office. Over 300 companies in Northern Ireland hold the license. You can apply to have either a Tier 2 General or Tier 2 intercompany transfer tiers added to the license, or both. You will usually need to evidence 4 specific documents for successful granting of the license, among other documentation. And it's worth remembering that 1 in 3 sponsor applications fail. This may be down to the fact that incorrect documentation has been provided. It may not have been provided in the format that the Home Office would expect to see. And that's where we come into play as legal representatives, in that often we assist new companies or startups, or indeed companies that have been in operation for a period of time, to get this sponsor license, to start off on the right foot with the Home Office. And we would help in assisting and putting together the documentation and information required for hopefully that to be successful. And the sponsor license itself is granted for a 4-year period, extendable every 4 years. It is also worth considering that it can take 3 to 4 weeks for a license to be processed by the Home Office. And therefore, I often recommend to clients that if you do consider bringing in a highly skilled worker, it may be an idea to get this license in place rather than putting a lot of pressure on yourself moving forward. Compliance and audits. Once a sponsor license is granted, there are compliance obligations placed on the employer. e.g., right to work, prevention of illegal working. The Home Office reserve the right, under the legislation, to conduct an unannounced immigration audit on the company every 2 to 3 years. That might take the form of you come into the office one Wednesday morning, you come in with your coffee, you sit down at your desk, and next thing you know, the Home Office have come in demanding to conduct an audit on the company. You have a number of options, which is beyond this webinar, but certainly it is advisable that if the Home Office do come in to the company unannounced, that you try to at least facilitate that audit best way possible. A focus will be placed on how migrants sponsored under the license are tracked, recruitment practices, monitoring, and whether reporting obligations have been met with the Home Office. If issues encountered, the Home Office can suspend or revoke the license, and in some circumstances issue civil penalties. In a recent case in 2013, the court outlined the Home Office are entitled to maintain a fairly high index of suspicion and a light trigger with enforcing compliance. Some concluding remarks. Highly skilled migrants can be brought to the UK if the points threshold is reached. Tier 2 general and Tier 2 intercompany transfer are the main visa categories to hire employees to the UK. Company must obtain a sponsor license to hire highly skilled migrants with the Home Office. And there are a number of ongoing compliance obligations which must be met, especially in the event of an unannounced audit by the Home Office. I thought it would be also topical and important to touch on Brexit considerations. Certainly with the introduction of the new EU settlement scheme, which has currently been piloted and then will later be introduced on the 30th of March 2019, it is advisable to consider whether if you have European members of staff, i.e. non-British or Irish nationals, to consider obtaining either pre-settled or settled status under the new EU settlement scheme, if indeed they have been with your company for a period of time. Now, I must stress there is no legal requirement to do so, but Theresa May has recently outlined that no Home Office fees will be payable for European migrants to apply under the new scheme. I think for any business, it's worth considering making sure that European nationals are registered on the new scheme to regulise their immigration status, and also it will provide an opportunity for any employer to complete right to work checks moving forward. Other considerations with Brexit are the likeliness that European nationals may well face a points-based system very similar to what non-European migrants are facing in the form of Tier 2 visas, which we've covered in this webinar. So it's likely in about 2021 that some of these changes will take place. And just to finish up, that if you do have any questions or you wish to clarify perhaps an immigration issue, that my contact details are all included within the following slide. Whether you decide to contact me via email or telephone is entirely up to yourself. But either way, I would be happy to listen, to find out what your immigration requirements are for your business and whether Cleaver, Fulton, Rankin can assist in any way. I should also state that this is the very first webinar by the business immigration team here at Cleaver, Fulton, Rankin. And should you have any ideas of topics that you would like covered in 2019, we would be very receptive to catering for that. there are a number of changing immigration issues that are going to be happening this year. So it is a very exciting time. Thank you for tuning in today and look forward to joining in the future. Thank you.